Hello to everybody, this is Dr. Maryam from Mohammed Bani Hashem Advocates and Legal Consultants. And this week, this time, we decided to discuss an interesting subject related to the latest changes in the UAE law and UAE legislation related to inheritance procedure, and also to ask frequently asked question, do you still need a will or you don't need a will if you want to secure your assets such as movable or unmovable property. So coming back to the point, recently we all faced changes in family law and also in inheritance law in the UAE. These changes, they reflected the procedure that will be implemented in the court once the inheritance case is raised. So earlier, a lot of residents and a lot of people, they were confused that in the UAE courts during inheritance procedure, the UAE local law and Sharia law is applicable. So that's why people, they were frustrated how to secure their assets. So right now, due to changes, all the foreigners will be able to go for the law of the country of the person who passed away or who deceased. So it will make easier and it will make simpler the procedure of inheritance. What was earlier? So earlier, of course, by must, the federal law was applicable and Sharia law was also applicable. Right now, I think when we will have, of course, cases in the court and we will have some examples, practical examples, how the procedure will look like, most probably each and everybody should submit the proof of the certain documents, and also most probably the details about the scope of beneficiaries in this particular case. So the court will know how this procedure look like in the country of the person who passed away. So basically this knowledge most probably should be submitted to the court, so the court, the judge, will be aware how it looks like, so how the transfer of the shares should be. Because when we had cases in Dubai or in other Emirates, we always had to submit a certificate of the scope of beneficiaries. So this certificate show for the court how the foreign law looks like, how the foreign transfer should be. I see some of you, they are writing in the chat. If you have any questions or you want to share experience or you want to give any kind of comment, please go ahead. I will delightedly share the reply or share your thoughts, okay? So basically, I think that this document most probably will still be necessary to be submitted in the court. A lot of people, they had kind of doubts. So basically, do you still need a will, and if everybody is entitled to make a will? This question is very huge and very wide. How exactly to secure your assets? So I want to comment that these changes, they will not be automatically reflected in the cases where there is real estate, so where the property is in the scope of inheritance. So if the person who passed away earlier bought some property or purchased some property, maybe it's villa or apartment, whatever. So here in this situation, still UAE law will be applicable, because this is the must and the rule in the legislation, that the law of the country where the property is located should be implemented in the inheritance procedure. So what to do in this situation? What is the solution? So first of all, here we still have to differentiate the religion. if the person is Muslim, there are still restrictions about making a will. If the person is non-Muslim, he can do a will. And in case he wants to secure the assets, and in these assets there is a real estate, there is a property included, definitely it's better to make a will. If there is no property included, maybe you can skip the will and maybe you will avoid it. But still there is a difference. In UAE, if you have desire to make a will, you can do it in different places. We had a lot of videos earlier related to the wills and how to do it, where you can do it, but I will just briefly repeat myself. So being non-Muslim, you can make a will in the court, you can make a will in the DIFC, will in registry, you can make a will in Abu Dhabi as well, if you have a property in Abu Dhabi. There is of course difference in procedure, in language, and in the fees, so it all reflects the situation. But however, the big difference is that if you register a will with the notary public or you register a will in Abu Dhabi in judicial department, this will still be proceeded in front of the judge. So the judge has to see it and he will go through it to see if everything is okay, and he should approve the wish of the deceived person. If we are speaking about the DIFC will, then upon the probation period, it will not go to the Sharia court anymore. It will go to the DIFC court, the English court. So this is the biggest difference for your understanding. Where to make a will, it's only a wish and desire of the testator. So if he wants to do it in the court, then he has to understand the consequence. So his beneficiaries will have to go to Sharia court still and have to raise a case and have to get an approval from the judge for the shares to be transferred in this particular way that is reflected in the will. If he will go to the DIFC courts, then he will have to understand that his beneficiaries will go to the DIFC courts and they will get an approval there. So this is the big difference. So depends on the situation, you can understand what is better for you, what is affordable for you, what is easier for you and your future beneficiaries, how they will do it. I can also comment that there have been a lot of questions about the Muslim people doing a will and how is it necessary. There have been a lot of doubts. I can say that from the law, the Muslim person is entitled to make a will only for the people who are not beneficiaries and only on 30% of the whole part of his assets. However, I have been going through them comments and some modern directions, and I can say that right now people, they are trying to make a will being a Muslim. However, they try to take some letters from their beneficiaries that they don't mind, no objection letter, that they don't mind that his wish will be like this. So they will reject their share and they will not claim for it. But from the legal part, from the legal perspective, I can say that still this is not 100% guarantee that once the case will go to the court, they will not appear in front of the judge and they will not say that it was not our wish, this is not what we wanted, so they can basically object this part. This is from the practical point. So whether you will go for it or no, you decide. Also, on the top of the wills, there is also a trust. Trust is a different document, and we can compare it. It looks like present, a gift, but trust is still a different document, and it's implemented in the DAFC. If you want to go for the trust, being a Muslim person, you can do it, so you can secure your assets. However, if you don't have a will with the new changes, you have to go to the Sharia court, and if you are a foreigner, if your beneficiaries they are foreigners, they will have to work on the law of the home country of deceived person, and they have to understand what's the share will be legal for them in accordance with the law of the home country. So these are the basic changes what we faced. In my opinion, it's very positive. So it gives more options and more security for the people who pass away. And most probably they know their law of their home country, so they understand this law. So they will predict what the share can be in the end of the matter to them and to other beneficiaries. There was a question also: can the foreign will be implemented if it's related to the real estate? The answer is no. But still, you can submit it to the court. You can submit it to the judge. The judge can see it, and the judge can take it in consideration as one of the documents. But this is not a must. And if it's related to the real estate, you have to have a will that is registered in UAE. This is highly, highly important. Otherwise, this is not a will, this is just a document, one of the documents that you are submitting. So I hope this video was useful for you. As a conclusion, do you need to make a will or no? I can suggest, if you have a real estate, yes, you have to make a will. Where you have to make a will, it depends about circumstances. It depends where your assets are located. If you are ready to afford DAFC, it will be easier for you if you are native English speaker, or your beneficiaries they are native English speakers. It will be most probably the convenience jurisdiction for you. If you are not suspicious about going to the Sharia court in the end of the matter for your beneficiaries, if they are Arabic speakers, or they can go for this procedure, you can make a will in the notary public. It will be also applicable in the court upon the review of the judge. So this is the procedure. I think that inheritance question was one of the most suspicious one, and a lot of comments of the people who were afraid that the government will take their property, or nothing will work out, the kids, the wife, nobody will take anything if the person has passed away, so there is no security. I can say that this is not exactly like this. There is a huge scope of options that you can go for if you want to secure your assets. I did not comment about the assets that are in the bank accounts, the assets such as share in the company, the assets such as unmovable property, for example, car or something like this. So there have been also some changes related to the bank accounts. If you have joint bank accounts, it will be easier for you now, and in case one person passes away, the other one will have right to take the money. So this is, you have to contact with the bank. There is nothing, there is no necessity to make a will, to be honest with you. If you want to do it, if it's a part of your assets, you can of course include the bank account. But if this is only about the bank account, there is no huge necessity to make a will. If we are talking about the car or some presents, maybe some gifts that you want to take, and again there is no property included, you can make or a will in the notary public, or you can just wait for the case to be seen in front of the court, in front of the judge. If we are speaking about the shares in the company, here most probably it's better to make a will and to make some certain authorization letters inside of the company. So here you have to work more hard. I hope it was useful for you all. Thank you so much for your attention, and in case anybody of you has questions or still has some doubts related to the inheritance or succession procedure, please share your questions, your thoughts on the email. Subscribe to our social legal one on YouTube, Facebook, watch us live on Instagram. It was Dr. Maryam from Mohammed Bani Hashem Advocates and Legal Consultants. Thank you all for your attention, and goodbye.